SJC-13706, Commonwealth versus Gary Mosso.
Attorney Rudolph.
Good morning, and may it please the court, Paul Rudolph on behalf of the appellant, Gary Mosso. With me is attorney Michael Huzzy. In this case, the trial prosecutor, who was the district attorney's trial chief counsel at the time, testified that Mr. Mosso's lawyer never even approached him to discuss a plea, and that had Mr. Mosso wanted him to do so, in his opinion, that complete failure fell measurably below the level of an ordinary, competent, fallible attorney. The trial prosecutor's opinion on this issue is correct. And whether this court deems this complete abdication of the lawyer's constitutional obligation to his lawyer.
So we defer to the witness, not the judge's finding on an ineffective assistance claim?
Well, I guess I'm not sure which finding you're referring to, Justice Graziano.
You said it fell measurably below. You said the trial attorney's opinion, correct?
Yes.
Right. And we have a judge who had a hearing who had a different opinion. So why should we defer to the trial attorney's opinion rather than the judge's?
I think at the end of the day, it's a legal conclusion as to whether or not this failure to engage in plea negotiations constitutes ineffective assistance of counsel. I'm saying that it's not dispositive at all, but I think the fact that the trial prosecutor himself said in his opinion that this was deficient performance, that means something. And my view is he was right about that.
Why did it take so long for the defendant to bring this up? This is the fourth motion for a new trial.
Because Mr. Mosso did not know until 2016 that his lawyer didn't engage in plea negotiations. He found out when his co-defendant, Mr. Sinnott, had filed a motion for a new trial, which included an affidavit from the trial prosecutor in which he said, yes, Sinnott's lawyer talked to me about a manslaughter plea.
Didn't the judge not credit that?
No, the judge did not discredit his testimony that he didn't know about the fact that his lawyer didn't engage. There's no finding by the judge discrediting that testimony. And there's, in fact, I think he actually credited that. He didn't say this was, he didn't find that there was waiver. He didn't say he could have raised this at some earlier point. So there's no finding whatsoever that he knew before 2016 that his lawyer had failed to engage in plea negotiations.
Critically, did the judge credit the defendant's testimony that he asked his attorney to explore a plea?
He did not explicitly credit it. What he did, and
I was confused on that.
yeah, it is. I agree. I think it's somewhat confusing because of the way he wrote the decision. And it's particularly confusing because you had these two separate hearings that were spaced apart by many years, and which he essentially cut and pasted large portions of his ruling in this case from his ruling from Mr. Sinnott's case.
So is there an ambiguity in your mind as to whether or not he credited the defendant's critical testimony on that score?
I think the best reading is that he did credit his testimony.
Yeah.
Here's why. Because in his findings of fact, and this is in my addendum at pages 35 to 38, the motion judge recites a summary of Mr. Mosso's testimony. It's about 3 pages long, and it covers his testimony about the trial as well as his plea, includes his request to his lawyer to seek a plea. And then at the conclusion of that summary, he explicitly says what he discredits. And it does not include his request to his lawyer to seek a plea. So he could have said, I credit each and every one of these things.
What did he discredited which point? He discredited the point that the lawyer didn't inform him about the different consequences of first degree and second degree murder. Is that what he discredited?
He said,
it's not the clearest thing on our.
Yes, he says, I therefore do not credit Mosso's assertions that he did not understand the pleas available to him, which Mr. Mosso didn't really say, actually. He said he did understand those from talking to other inmates. And then he said, and that Attorney Clifford did not review this information with him. So what he's discrediting is Mr. Mosso's testimony that his lawyer didn't talk to him about available pleas, I guess. But he's not discrediting his testimony that he asked his lawyer to seek a plea.
Right. So
What do you do with the fact that Sinnott's lawyer never requested pretrial second-degree murder? And that was what DA Alois said would have been potentially palatable for the DA.
What Alois testified to was that, and this was at Sinnott's hearing, maybe more so than at Mr. Mosso's hearing, was that he would have wanted a plea for both of them. And I don't think that's surprising. I think many prosecutors—
Right, but he rejected the manslaughter plea, and he was looking for a second-degree murder plea. He thought that was the most apt, appropriate. And nobody on Sinnott's side requested that pretrial.
And Alois said, I would have wanted both of them to plead. But when he was asked directly at the Rule 30 hearing for Mr. Mosso what he would have done had only Mr. Mosso wanted to plead, but Mr. Sinnock wouldn't accept a second-degree murder, he said, I don't know what I would have done, but I think I would have done it.
But in the Sinnott motion for new trial, he made different findings, right? The judge made different findings, which was that only both, not just one.
Well,
And the judge then discredited Alois's testimony in the Mosso hearing in favor of what he had previously concluded in Sinnott.
I don't agree that he discredited Alois's testimony. I don't—
No, that portion. He wanted both or none.
I don't think that the judge said at any point that he discredited anything that ADA Alois testified to. He simply said Alois testified that he would only do this if both pled. And that's just not correct. That's not what
But
Alois
he did testify that way in the Sinnott.
He didn't. He testified that he would have wanted a plea for both of them.
What is the difference in your mind?
I think most prosecutors would want a plea from both defendants in a situation like this. The question is, what would he do if only one wanted to?
Well, we know because Sinnott wanted to, and he rejected it.
We know that—
Not only Sinnott pretrial wanted manslaughter, and after, I think, 2 weeks of trial or several days of trial, wanted the murder too. Both were actually rejected.
Right, but we don't know, and this is part of the problem with engaging in prejudice analysis in this situation, is this is a necessarily highly speculative inquiry. What would have happened in this alternate universe?
Who has the burden of proof?
Well, I think there's a question as to whether or not prejudice analysis is even appropriate.
Assume for a moment that it is. Please continue.
Yes. We have the burden of proof, right? Now, I think it's important to recognize that this court has articulated the prejudice standard differently under Article 12 than the U.S. Supreme Court has under the Sixth Amendment. And it's possible that that different formulation might make a difference here, or at least might be more useful in a situation like this. In Millian, this court adopted the standard of is there a serious doubt that the outcome would have been different had counsel's performance not been deficient? Whereas in—
Can I ask you to address the finding of the judge? The judge, as I can summarize it, basically says there's too much would have, could have in this case, which leads to speculation. And we have the trial ADA equivocating where he says, I don't know, maybe I would have.
Mm-hmm.
Isn't that really at the bottom here where it leads to this impermissible speculation that animated the judge's decision here?
Well, I think as the Supreme Court said in Gonzalez-Lopez, this is a necessarily speculative question. So there is always going to be some speculation as to what would have happened. The fact that it's speculative doesn't necessarily mean we lose. If the trial prosecutor had said, I absolutely would not have done.
Well, I mean, sometimes it can be more concrete, right? So if we have an ineffective assistance because the lawyer didn't hire an identification expert and should have, and then we look at the identification testimony, the available expert witness testimony, we can somewhat posit it would have been a different result. Here we have, well, you should have asked for a plea, and then we have the trial ADA saying, maybe I would have, maybe I wouldn't have. I guess I would have. And the judge says, well, that's too speculative.
And I think that the trial prosecutor saying, I don't know if I would have done it, I think I would have, that raises a serious doubt about whether there would have been a different outcome had Mr. Mosso's lawyer done what he was supposed to do, which is engage in plea negotiations. It doesn't prove definitively that there would have been but that's not the burden. The question is, has he shown that there is a serious doubt that there would have been a different outcome? And the trial prosecutor's somewhat equivocal, or equivocal answer does raise a serious doubt about that.
Can we go to the so we have a not very clear finding as to, in fact, no finding as to really whether the judge credited the defendant's testimony that he asked his lawyer to pursue a plea bargain. And you've made an alternative argument that even if we, given that there's an absence at least of an express crediting of that testimony, even if we assume away that conversation between the defendant and counsel, it was still ineffective assistance of counsel not to pursue a plea bargain in these circumstances. I assume you concede, do you concede that there was a strategic decision that here by counsel not to pursue a plea bargain? Are we in the strategic decision land or not in the strategic decision land in terms of manifestly unreasonable?
Meaning if Mr. Mosso had not asked him to seek a plea, is that a strategic decision? Yes, I agree.
You bear the burden of showing that it was manifestly unreasonable. You agree that you have, if we assume, because we don't have, if we assume that the judge did not credit the defendant's testimony that he asked counsel, you have to show that there's it was manifestly unreasonable here.
I would agree with that.
And so, and
Is
here,
that right? I just want to make sure I understand that, because I thought your argument was that this is within the defendant's control, that the defendant has the right to demand, to make sure, to instruct his counsel to ask for a plea. So the strategic decision-making of the attorney can override that decision? I just want to make sure I understand your answer to Justice Stewart's question.
Yeah, I mean, this is not my claim here, but I do think that if a defendant doesn't ask his lawyer to seek a plea, there might be circumstances where it's manifestly unreasonable for...
Here you're saying you have findings of fact that he asked his lawyer to seek a plea.
Yes.
Can the lawyer strategically override that decision?
No, that's right. So I'm saying where he asked him to seek a plea, the lawyer has a constitutional obligation to engage in plea negotiations. I don't think the lawyer can ignore it. This is the guy who's facing life without parole, and he says, I don't want to die in prison. The lawyer doesn't get to say, that's okay, I'd rather go to trial. This looks like a fun case to try,
so
whatever.
counsel, I think it's very clear to me that the decision below does not expressly one way or the other credit or discredit the defendant on the point of whether he had this conversation with his counsel. It's unclear whether the judge credited that testimony. I think the best reading of the judge's decision is that even if that testimony is credible, ... If we remanded for more explicit findings, we could get a decision from the judge saying, I do not credit. There's some stuff in the decision to the effect that he is not really crediting the situation here. He talks about the length of time that has passed, that the fact that there have been all these other motions and this has never been raised before. If the judge said he does not believe the defendant, that the defendant had those conversations, I thought that there was an alternative argument in your brief that even so, it would still be an effective assistance of counsel in these circumstances. Is that correct?
No, I'm not making that claim. I do think that Mr. Moss, that the obligation is triggered by the defendant saying, I want to seek a plea. So
so it all rises and falls on whether the judge credits the defendant's assertion that which he described as an assertion, that he did ask this of his counsel.
I think that's fair, yes.
Wait a minute, because now I need some clarity. Are you saying that if we even, forget about remanding it, if we were to presume the judge credit that you're saying that obviates the judge's findings about how speculative this would have been?
So the speculative question goes to the question of prejudice.
Prejudice, right. That's what I'm getting to. That you're saying that obviates the prejudice analysis?
I have made an argument, and I maintain this argument, that there is structural error where the lawyer opts out of this part of the process, to which the client has a right to counsel.
Are there any cases that deem this structural error?
There are.
I know you cited Watt, right?
There are not.
The lawyer basically not being there, but.
Right. No. And as I conceded in Marino, this court did engage in prejudice analysis. Now, as I was rereading Marino, I will clarify something from my brief, which is there is a discussion in footnote 20 of Marino where the majority takes issue with Justice Duffley's dissent about how you conduct prejudice analysis in failing to engage in plea negotiations. And all I would, and the majority sort of rejects the idea that this is not subject to prejudice analysis and that the defense has to show reasonable probability of a different outcome. That being said, I could only encourage this court to reconsider that, and to reconsider it, especially in light of what the U.S. Supreme Court recognized in Gonzalez-Lopez, where they recognized that the inquiry into what would have happened in plea negotiations is this highly speculative inquiry, and it's not, and therefore it is subject to. That was a choice of counsel case, so I don't want to say it's the same as this case, but in that case, the fact that the defendant didn't have his chosen counsel, one of the reasons they said it was structural error is you don't know what a different counsel would have accomplished in plea negotiations.
So how would we ever be able to really do this? If you're saying in this case, where you've got the trial prosecutor for one co-defendant who says, I rejected out of hand the manslaughter pretrial. I wanted both of them because the family needed a murder conviction. And so they would have both had to have pled to murder two in order for both of them to get it. The idea that there was this chance that Mosso would have gotten it if Synod didn't agree to it too, where at best he says, I don't know what I would have done. So I don't know what I would have done. So I don't know if Conti would have agreed to it. And I don't know if the judge would have agreed to it. So with all of these kinds of nesting issues, even with what you're saying, the formulation is the Supreme Court, how are we supposed to do that?
I don't think it's, in this case, I don't think it's quite as speculative as you're suggesting. I think that he testified, if he had recommended a plea to his boss, he would have gone along with his recommendation, and the judge would have adopted it.
That's only if we're talking. That's only if we're talking one vertical. That had nothing to do with whether or not Synod was going to be on board with that. That was talking about just Mosso.
But I guess what I'm saying is I don't think there was any equivocation that his boss would have agreed to recommendations he was making and that the judge would have adopted it. The question is, would he have made the recommendation? And I agree that he wasn't certain about that. And so what do you do with that? And that's why I suggested that I think in some ways in this situation, this court's formulation of prejudice analysis under Article 12 is more useful than the reasonable probability formulation under the Sixth Amendment. Is there a serious doubt about it? Yes, there is a serious doubt, because this trial prosecutor is saying, I might have done it, I don't know. That's a serious doubt. That's not, there's little doubt, there's no doubt. He's not saying, I really don't think I would have done it. I'm sure I wouldn't have done it. You could imagine cases where we can't meet our burden.
But there are multiple levels, though. There's first, what Synod would do. So whether Synod would drop his insistence on involuntary manslaughter, right? So you have that issue. Then you have the issue of if he does, are they both going to do? I mean, you just got a lot. You know, there are multiple, and whether Conti is going to agree to it if Senate doesn't do it. You know, there's a bunch of ifs there.
I agree, and I think that's an argument in favor of why this is not very susceptible to prejudice analysis. We're asking the courts and even the witnesses to engage in this level of what ifs that's almost impossible to tease out. And at the end of the day, assuming Mr. Mosso's testimony is true, that he asked his lawyer to try to seek a plea, his lawyer's choice not to engage in that process at all means he had no lawyer, and we don't know what would have happened for certain, or even close to certain, had he done what he was supposed to do, which is engage in plea negotiations on behalf of his client and not just let him go to trial, get convicted, and go to prison for the rest of his life.
Okay.
I see that I'm out of time. Thank you.
Thank you. Attorney Henry.
Good morning. May it please the court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. Judge Reardon here correctly denied the defendant's fourth motion for a new trial, where the defendant failed to establish that counsel rendered deficient representation or suffered any prejudice. I suggest the record shows that Judge Reardon actually did not credit the defendant's assertion. The defendant testified that he repeatedly asked his attorney Clifford to seek a plea deal, despite the fact that he testified that he was dodging his phone calls, he wouldn't visit him at all, and he only saw him 2 times, once at the probable cause hearing and once before trial, right before trial, when they met to discuss strategy. Yet in the same hand, he's arguing I repeatedly asked him to seek a plea deal. Judge Reardon?
Those are 2 instances, right? And doesn't he talk about the first instance, the motion to suppress or whatever it is? I can't remember. Isn't there there is a conversation after that proceeding?
Probable cause hearing, Your Honor. I was at the probable cause and they said they were in lockup and it was difficult to, there was something, there was a lot of people there. But my point is that Judge Reardon then finds, when he does his findings of facts, he says this happened, then he terms it
He
as.
actually doesn't. He actually doesn't. He says he testified to this.
He asserted this, that's what
He doesn't, he tends not to make what we ask the trial judges to do, findings.
He does.
He sort of summarizes a lot of testimony, doesn't he?
I would suggest he summarizes the testimony as fact, that he finds as fact, that Mosso had a difficult childhood growing up, that the defendant went to Bridgewater State and was evaluated. And then when he gets to the assertions, he says the defendant asserted, and then he drops a footnote and says, insofar as the statement contradicts Attorney Loyce, I do not credit it. But then he goes further. Even if accepted as accurate, if he had found the testimony true, he wouldn't have put it that way. But even if this court has ambiguity about that, it was cured. If I could just.
No, let me ask the question. If he had done this, I think, doesn't he say, he relies on the fact that he doesn't have a right to a plea, but that's the wrong legal analysis. The issue is whether he has the right to request his lawyer to ask for a plea. The judge sort of ducks the hard issue, doesn't he?
No, I feel that's because he doesn't credit the defendant's testimony. That's how he frames the issue. And if you let me finish my thought, I appreciate it. In the motion to reconsider, the defendant argues that exactly that you misconstrued my argument. I said I was repeatedly requesting you to seek a plea deal and you ignored my request. The Commonwealth's opposition, what I wrote, said he didn't misconstrue your assertion because he didn't credit your testimony that you repeatedly asked for a plea deal, and the judge denies it for the reasons stated in the Commonwealth's opposition. That was his denial of the motion to reconsider, where I specifically argued that there was no issue in the way Judge Reardon framed the motion because he did not, I said, as the defendant ignores the judge's finding that he did not credit the defendant's testimony, that he repeatedly asked Attorney Clifford to seek a plea deal. And Judge Reardon denies the motion for the reasons stated in the Commonwealth's opposition. So I would suggest any ambiguity is cured then with a judge. He could have ruled that in numerous ways, but he rules it by denying it based on the Commonwealth's opposition. I would suggest even if this court were to conclude the opposite, as established, the defendant cannot establish prejudice, as Judge Reardon found.
Can you, before you go to
sorry.
prejudice, can you address your opposing counsel's argument that, and I understand your position on the record that the judge did not actually credit the testimony of the defendant, putting that to one side, assuming for purposes of my question that the defendant had asked his attorney to attempt to obtain a plea, and his attorney had not done that. Would that be structural error as to which we don't use the prejudice?
Nope, structural error involves your constitutional right to a fair trial. That's what this court has always held. That's what the U.S. Supreme Court has always held. As this court and the U.S. Supreme Court has held, you do not have a constitutional right to a plea bargain in the plea process.
That's a little different, I think, to Justice Kafka's point earlier. The assertion is not that the defendant had a right to a plea. You know, D.A. Alois could have done whatever with the request. The question is, did he have the right to a counsel who followed instructions to try to seek a plea?
I do not think that constitutes structural error. I think there's a lot of things that come into play, it'd be a case-by-case basis. I think you have to still establish priors for the reasons I said. You have a constitutional right to a fair trial, which is what Mr. Mosso got here. Also, you have the Marino case, which says that it's a substantial risk of a miscarriage of justice. And even if we do want to say structural, it's been waived by this is the defendant's fourth motion for new trial, which was the Watt case. This court found that it would have been structural error, but it was waived and you allowed or reversed the defendant's convictions on substantial risk of a miscarriage of justice basis.
By the way, do I have this motion you filed that you say we should look at? I'm just looking in the appendices.
Sorry, it's in the defendant's record appendix.
Sure.
My motion to reconsider is 100% in the defendant's record appendix. I don't know the exact pages. I apologize for that.
You agree with the first premise, though, before we get to structural error or prejudicial error, that a lawyer has an obligation, and it would be ineffective assistance of counsel for a lawyer not to pass along a request for a plea bargain?
I think it's fact-dependent, Your Honor, to be quite honest. Like in this case, we have Attorney Clifford.
All right, assume that the defendant, Mr. Mosso, asked Attorney Clifford to explore a plea. Do you concede that would be ineffective assistance not to talk to the ADA?
I do not, because at this point,
Why?
because at this point, he is aware that that Senate's attorney has been repeatedly requesting a manslaughter conviction. The record and reasonable, credible evidence that was before the court suggests that Mosso was only looking for a manslaughter. We learned that during the trial, actually in the middle of the trial. Clifford brings that out during the cross-examination of, I think it was Trooper Hanlon. And also it was in some of the filings that he thought the night to induce him to the second statement, he was asking for a manslaughter or thought that he was going to get a manslaughter. And then you have Attorney Clifford knowing that Senate's been repeatedly requesting a manslaughter, I think 10 to 15 times was the testimony, and was repeatedly told no. And then we have a district attorney's office that does not offer pleas, but only accepts pleas. So now he's boxed into a second-degree murder plea. And I think if he goes back, which we don't know because Attorney Clifford has died in 2008. So this claim is raised well after the attorney who could explain his reasoning as to why he didn't approach or credit or discredit, whatever. We're stuck here where we don't know what would have occurred.
With all these moving parts going along, you still maintain that had the defendant asked his lawyer right before trial, please ask them for a second degree, that not would be, he has the ability, and he's represented his client in a constitutional way to not pass that along and not request?
I think in that, like I said, it's fact specific. I think I agree with you on that one. If Mosso had gone to his attorney and said, please get me a deal to second degree murder, I'll do that. I would say in that circumstance, yes, that would be, you would have the first prong of Safarian satisfied, then you'd have to go on to the prejudicial part. That's why I think it's very fact specific as to what exactly occurred. You could have a case, say Mosso asked him, and this actually happened to me in a murder case, seek a plea for assault and battery with a dangerous weapon. There's certain asks that are just, a reasonable attorney I would suggest wouldn't go to the prosecution with that because it's a delicate dance they play and you might lose credibility in your position if you're asking for what I would suggest there would be a ridiculous claim, which is I would not ask for assault and battery with a dangerous weapon. So that's why I think it's very fact specific.
You could do that without telling your client that that's what you were doing?
No, you could tell your client I'm not going to them with that because that is
but
not.
Here the record is that Mosso asked his attorney to seek a plea, and his attorney said, yeah, they're not doing that, even though his attorney had never approached the DA. I understand you dispute that, but just for purposes of my question, that would be not ineffective assistance? I can see counseling your client, that's just not something the DA is ever going to accept, whatever, you know, that would be maybe effective, but just to lie to him?
Yes, I agree. If he completely lied to his client, then that would be the first prong of ineffective assistance, and then you'd move on to the prejudice part.
I want to go back to something you said and make sure I understood it correctly. Are you saying that there is something in the trial transcript that will reflect that Mosso was looking for a manslaughter outcome as a plea during the trial?
It was the only thing that was brought up, and it was in the middle of trial, and it was regard to his statement to the police that he suggested, and it was rejected. But that's the only thing on the record we have. I'm not saying he asked for it, but if you do look at the cross-examination of the trial transcript of, I think it's Trooper Hanlon, he says that his attorney, Clifford, crosses him on, well, weren't you willing to offer him a manslaughter? And that's why he gave his second statement. Isn't that trying to infer that? My only point of that is that the only thing on the record, it seems as though reasonable inference was that he was looking for a manslaughter. There's nothing on the record that said he was looking for a second degree. But even if this, no, there's nothing, I don't want to mislead you. There's nothing that would say like Mosso is willing to offer a plea to manslaughter. There's nothing on the record that says that.
And did you make this argument, or I don't even know if it's an argument to the judge in connection with the motion for new trial?
No, my argument was that the defendant was not credible because of his, on one hand, he keeps arguing, I've repeatedly asked my attorney this, and he kept coming back to me. The way he words it, to me, is not plausible with the fact that I only met him twice. I kept asking him to seek a plea deal, and he kept coming back to me saying, I'm working on it. I forget his exact words, if you give me 1 second. He says, I saw him several times to check into a plea deal. He visited me at jail. I said, why don't you talk to the DA so I can make some deal? He says, Attorney Clifford says back to him, I'll talk to him whatever. He may be willing to do that. He just, quote, kept coming back to me with, I'm looking into it, and finally told me the DA's does not enter any plea deals. And you have that with him testifying that this attorney was dodging his phone calls, was dodging his family's phone calls, and then he only met him twice in person.
If we were to look at the evidence that you pointed to, that he had been seeking a manslaughter plea from the police somehow, doesn't that undercut the notion that his affidavit, at least to the extent it says that he asked his counsel to pursue a plea deal, is not credible? Because if he was looking for a lesser resolution, even as early as speaking to the police, doesn't that buttress rather than undercut the notion that he also asked his counsel?
It could, but also Attorney Clifford is aware, again, that that is not happening because you have Senate attorney 10 to 12, 15 times asking for a manslaughter.
Sure, I'm not asking you about whether or not the prosecutor was open to a manslaughter plea. I'm just trying to delve into how you understand, or how to understand myself, this evidence you're pointing to about the defendant seeking a lesser resolution even earlier. And why wouldn't that buttress rather than undercut his contention that he asked his counsel to pursue a plea before trial?
I guess the Commonwealth's position, if I make it clear, is that that is not credible, that he did not ask anything. That's the Commonwealth's position argued at the motion for new trial, and it's the position here that the defendant lied when he said, I repeatedly asked my lawyer to plea deal. The Commonwealth's position is he never asked Attorney Clifford for a plea deal. He wanted to go to trial, and that's what Attorney Clifford told Attorney Alois, that we're going to trial. That's the Commonwealth's position. I'm sorry if I confused it. I want to clarify that that is the Commonwealth's position, that he never requested it. He wanted to go to trial. And that's the Commonwealth's position, that Judge Reardon correctly discredited his assertion to the contrary.
I just read your motion for reconsideration. You have like 6 or 7 different arguments in there. So it's not like you argued that this wasn't requested and that was the only thing you argued. When the judge writes for the reasons stated in the Commonwealth's opposition, we have no idea which reason he adopted, right?
Well, given his lengthy opinion, in his original denial.
Again, just back to the thing, the motion for reconsideration you just emphasized to me is just basically your brief. It's the same arguments you made in this case, all the different ones, that you have no right to a plea, all the different ones, right?
I made 6 or 7 points in there, correct, Your Honor?
Yeah, so you didn't argue just this single point that, about the facts that he didn't request this.
Well, I argued, respectfully, I argued that when the defendant says you're confusing my claim with Sinnott's claim, you're using the same language you used in your denial of Sinnott's claim. And here's the difference between our two claims is that Sinnott never requested a plea deal. And here I argued, again, one of the many things, you're correct, I did argue 5 or 6 things in there, but one of the things I did argue was like,
We just don't know whether the judge, the judge's fact finding on this point is not clear, even after the motion for reconsideration. Right?
respectfully, I disagree, but if this court were to, and if the court doesn't find the prejudice part, then the Commonwealth will have no problem with a remand to Judge Reardon to clarify his findings. But I do believe on the prejudice part, even if this court were to credit the defendant's assertion that he repeatedly asked his counsel, as Judge Reardon properly found, it's way too speculative. And indeed, during the hearing, Attorney Loyce himself on cross-examination, when this was question about this, he finally says he actually says it's too speculative. I don't know what I would have done. And you had a family that was vehemently opposed, that made the record, that wanted a first-degree murder conviction. Attorney Loyce testified they would have vehemently opposed any.
Actually, counsel, can I interrupt you there? So I want to talk about the speculative point because it may all rise and fall on that. And it strikes me that there's a lot more to the defendant's case here on prejudice than is just this bottom line one answer from the ADA that he wasn't sure. So the ADA testified that he thought this was a weak case for first-degree murder and was concerned about it. He said, I think he described it as sort of, he had a good faith basis for seeking first degree, but there's intoxication there and so on, and he was concerned about it. And he testified that he unequivocally testified that in every single murder case he'd been able to convince a family to go along with his plea recommendation, and that if he had decided to recommend second-degree murder here, given vulnerabilities in the case, he was certain that he would have been able to convince the family, even though he did agree they would initially have been against it. So we have the ADA saying that he really thought that this was a second-degree murder, stronger for second-degree murder than first-degree murder, and then he could convince the family, and he was unequivocal that his DA had always accepted his recommendations, and that he was certain that if he came to the conclusion of a second-degree murder, his boss would accept it, and for reasons that he specified, the judge would accept it. So the only, in all of that chain of logic, which is quite a lot of evidence, there is, as you say and point out rightly, like this one degree of question where he's not sure about Sinnott, and if Sinnott had not gone for it. We do know that Sinnott was seeking a deal, that he repeatedly in this informal way sought manslaughter, and then later in trial did seek second-degree murder. So I think it's unclear at best what Sinnott would have done if Mosso had said, I'm pleading to second-degree murder. We don't know what Sinnott would have done, right? We don't even know that Sinnott would have not gone along. So we're left with this scope of uncertainty that's pretty cabined. It's just, would the ADA would have gone along? He says, I think so, I don't know. So I guess I'm posing back to defense counsel's argument, which is, what does it mean for there to be a serious doubt that the result would have been different in the context of a plea? What does a defendant have to show to raise a serious doubt? It strikes me that it's not plausible that the defendant has to absolutely show he certainly would have gotten a plea bargain. Do you agree with that?
I would, few things, Your Honor. First, under Marhino, the thing the defendant has to, in the context of a plea, has to establish that has the burden to demonstrate a reasonable probability that the prosecution would have made an offer, that the defendant would have accepted it, and that the court would have approved it. And that's the standard he has to prove here. In regards to Attorney Loyce's testimony as to how he valued the case, I did think it was quite interesting. Attorney Loyce, who's now been a criminal prosecutor for 30 plus years, and then you had Attorney Attenberg, who's a longstanding criminal prosecutor, a longstanding defense counsel as well, viewed the evidence differently. Attorney Attenberg said this was a clear-cut first-degree murder, a very good case of first-degree murder, and that's why he believed that Attorney Clifford was so ineffective because he should have seen that the evidence was overwhelming and that it was a very good case for the Commonwealth for first-degree murder. So you have two highly respected criminal defense counsels looking at the evidence in totally different ways. I would also suggest that as Judge Reardon found, it had to be a global resolution. So he was not going to put this family through a trial of one and then go to trial in the second one, particularly where they're so immediately vehemently opposed to this. And I thought that Judge Reardon, which I quoted him in my brief, based upon this degree of speculation of what would have happened if Senate's attorney behaved differently, if Attorney Clifford behaved differently, if Mr. Conti then accepted this plea deal over the victim's objection, and then what the judge all would have done back in 1984. And I believe he was correct in finding it's too much speculation to show that the prosecution would have made an offer, the defendant would have accepted it, and the court would have accepted it, because we know that the prosecution did not make offers, and we also know that even if one approached it, the other one also had to take it.
Chief, can I ask one other question? In terms of the strength of the prosecution's case, can you just remind me, was Attorney Eloise's testimony that the premeditated murder was weak and that the extreme atrocity or cruelty was actually very strong?
He did testify he thought that they didn't have an unpremeditated, deliberate premeditation. He thought it was a good case, but he thought there was issues with extreme atrocity or cruelty given the defendant's intoxication at the time. He saw that as hurting his case. That was his testimony, that he was concerned for a first-degree murder conviction. He was not going to take a manslaughter conviction. That's why he testified he thought second degree would be appropriate. And then you have Attorney Ettenberg, who says, no, this was a very, very strong case for the Commonwealth for first-degree murder.
Thank you.